I will now call case number 125318, State of Kansas versus Dotson.
May it please the court, Peter Meharry for appellant Zshavon Dotson. This case comes before this court after two friends got in a verbal argument that unfortunately escalated into a physical fight over a gun. That fight left one of the friends dead and my client charged with first-degree premeditated murder. He was ultimately convicted of that charge and sentenced to life in prison. Below in the criminal proceedings, there are what I would say two major issues. The first one being self-defense, whether or not self-defense applied in this case. Then the second issue I believe was important was whether or not there was any evidence of premeditation. The issues that we've raised in our brief, at least the first few 3 or 4 issues, address those key issues. And what I'll start with is the prosecutorial error issue, because I believe that does touch both of those issues. We believe the prosecutor in this case, in closing arguments, made misstatements of the law as far as self-defense, and also improperly diminished what was required for premeditation. During closing arguments, the prosecutor repeatedly said that if you start a fight, you don't get to claim self-defense. While self-defense may be more limited if you are the one who starts a fight, or otherwise the initial aggressor, it is still an available defense. But the state painted a black and white picture for the jury as to those two doctrines. And they said they are mutually exclusive.
I'm sorry to interrupt your argument, but I'm not so sure that's completely the way I read the record. And you tell me if I'm misreading it and why. Because the statement, you cannot claim self-defense, was said, but immediately preceding that, the prosecution explains the jury instruction, including the requirement for initial aggressors to exhaust reasonable means of escape. Then says that didn't happen here, factually, because there was reasonable means of escape. Then makes the comment that you're challenging here. I'm just thinking, when you put that in context, why isn't that an accurate statement of the law as applied to the facts as the prosecution viewed them here?
The problem is the prosecutor does at times say you have to exhaust reasonable means of escape, but it always goes back, the prosecutor always goes back to that quippy line, if you start a fight, you don't get self-defense. That's the fallback. And that would mislead the jury into believing that they are mutually exclusive. And that's something I believe the state conceded in their own brief. If you look at page 8 of their brief, the state says the jury either believed that Dotson was the initial aggressor and self-defense did not apply, or they did not find Dotson credible and did not believe self-defense applied at all. The state is saying the jury was misled into believing if he's the initial aggressor, self-defense does not apply, and that is not the law in Kansas. And in this case, self-defense was the main issue at trial, and it was critical for my client that the jury fully understand how to apply that defense to the facts of this case. And the state's comments misstating it were critical and prejudicial, and we believe warrant a new trial in this case. Additionally, we believe the state improperly diminished what was required for premeditation. In this case, the state said in closing argument, it's just more than instantaneous. The state talked about how it's no big deal whoops, that it's just more than an instantaneous killing. And we believe that that is watering down premeditation such that it is basically no different than an instantaneous killing or an intentional killing. So we believe those comments go to two critical aspects that were heavily litigated at trial and improperly led the jury away from properly applying self-defense and properly considering the evidence in support of premeditation.
How is saying it's more than instantaneous, watering down the standard to instantaneous?
Because when you're saying it's just more than instantaneous, I think that's saying it's basically the same. That's what
That-
you're
I mean,
conveying.
Can you help me syntactically as a matter of, I guess, definitionally, that's not what it means. I mean, the word more means something in addition to. So help me understand your argument that saying more than is actually just saying, no, it's just instantaneous.
They're saying it's, quote, just more than instantaneous. And that would give the impression it's fractions of seconds.
So is it the word just that you are objecting to?
That is part of the problem with this comments the state made in this case, Your Honor. In addition, it talks about how it's no big deal. It's not like Hollywood. You don't need to show a plan. We believe that what the state was conveying was something less than premeditation is required to convict of premeditation. They're watering it down such that any intentional conduct by my client would suffice to find premeditation.
I thought the argument also, and maybe this comes from the pro se briefing, but the argument was that the focus exclusively on the temporal element of premeditation without discussing or acknowledging the cognitive component, that it's not just about time, it's about time for thoughtful deliberation. That's that there are two components, and by never acknowledging the second cognitive component, that this case is sort of like our Coleman decision. Is that part of your argument that has been briefed and preserved for our review?
I believe, to the extent the state is only talking about the time element, I believe it is like Coleman, where this court talks about how it focused on time and it's watering it down, as I said, that it's limiting, so it takes basically next to nothing as far as the time element goes to show premeditation.
Are you saying that anytime the prosecutor talks about the temporal element, they must also talk about the cognitive element in the same conversation? You're saying they can't split those two things up?
I don't know that I'm necessarily saying that. What I'm saying in this case, the prosecutor was watering down the time element to next to nothing. Certainly.
So that, just to clarify, that sounds like when you were answering Justice Wall's question, what you're saying is you really are just focused on the time element.
In this case, I am.
Okay.
Because it's the comments about it's just more than instantaneous. It's no big deal, stuff like that. They are saying it doesn't take any time. Premeditation can be in an instant. And that's what they're conveying to the jury. And in a case where we're arguing that there's insufficient evidence of premeditation, that was critical and certainly prejudicial to my client's defense. Because in this case, the evidence, as I mentioned at the top of my, I guess we'll call it a speech, was that this was a fight over a gun. It ended when my client was able to wrestle the gun away, and the testimony from the state's witness was he immediately shot. No hesitation, no thought process. He immediately shot once he was able to get control of the gun. We believe that the timing and what the witness said shows that this was not a premeditated murder.
Typically, the shooter is firing more than once. Those second, third, fourth shots are often seen as evidence of premeditation.
This court has looked at other cases and said, the number of shots or the number of stab wounds can be used to show premeditation. That is this court's case law.
Yeah,
That was the testimony at trial, Your Honor.
Question is, why can't we look at, regardless of whether the two shots to the groin later or the fatal shot or the previous, why isn't that corroboration of premeditation?
Well, first, I would say you have to look at, this court has said, actions and what led up to the homicidal act. And it has to be conscious deliberation before the homicidal act. That's what's required for premeditation. And when you go down the road where you're going to say, okay, we're going to look at what happened after the fact, I think you go down the road of making anything that's intentional suddenly premeditated. There was no indication prior to the initial shots that my client had any plan, any intent to kill prior to those initial shots. And the fact that he shot him again after the fact, I think shows more evidence of an individual who was just involved in a fight for his life and probably having a lot of emotions and rage, probably because they were in a fight, such that he shot him again.
We would call that emotion rage part of the cognitive process. Why you make somebody really bad?
Well, I don't think there was any question that the first shots were fatal. The testimony at trial was once those first shots were made, the victim did not move. He was dead. It was clear. So actions after the fact, I don't think somehow go to prove some sort of premeditation before the fact.
Well, the coroner's evidence suggests that, I mean, it's possible the victim was still alive at the time those last shots were fired. As I recall from the record, the coroner testifies that definitely those were the fatal shots, but it would have produced death at the longest 2 minutes. And then the victim's mother testified that those final shots came 1 to 2 minutes after the first set of shots. So these second sets of shots, the victim might have been alive. Does that matter? Or does that change the analysis
Well, I would
on
say
a sufficiency
Sure.
challenge?
I would say two things. Number one, the testimony also was that those initial shots would be immediate incapacitation. And I think secondarily, the testimony from the eyewitness was that he did not move. Her testimony was bam, bam, on floor dead. That was her testimony. So I don't think you can say or look at additional shots to show premeditation in this case, given how it played out and what the testimony was.
And if I can just ask one final follow-up, I know I'm taking up a lot of your time here, but I asked the question, Justice Stiegel followed up, and I'll just ask one more time. In your 609 letter to the court, you cited Coleman, and I just want to make sure that that citation is in support of your argument as to prosecutorial error regarding minimizing only the time component of premeditation.
That was the argument we raised, and that was a similar argument that was made in Coleman. So that's why I 609 it, is that in Coleman, they diminished the time element, and here we think the state did the very same thing.
But not the cognitive component.
No,
Okay.
I don't think there was any evidence of any cognitive element in this case, which is obviously why we're arguing sufficiency in this case. So for those reasons, I would ask that this court reverse this matter. One thing I would, I guess, this is a little different ask than I usually have. We believe there's insufficient evidence for first-degree premeditated murder. Even if this court believes that a new trial is warranted because of other errors, we believe it still must decide the premeditated murder issue. And if it does find insufficient evidence, remand it for new trial with the top charge being murder too. Thank you.
May it please the court, Kayla Rayler on behalf of the state of Kansas. There was sufficient evidence to establish that Dotson had completed the cognitive process to form his premeditation prior to killing RJ when he was standing over him. The evidence at the trial through the testimony of Ms. Marks was that Dotson lunged for the gun, grabbed the gun. That is when RJ grabbed for the gun. She sees this struggle over the gun. She runs to her bedroom to get her gun from under her bed, runs back out, gets knocked in the head by Dotson, leaving a goose egg on her head, causing her to lose consciousness, gain consciousness again to see her son and Dotson move from where she saw them last to down the hall, fighting over this gun still. Dotson pushes RJ into the wall and RJ loses his grip on the gun. He falls to the ground, and that is when Dotson decides to straddle over RJ, pointing a rifle at RJ and shooting him in the chest.
Well, that's not what the record said. The record says that it was instantaneous, the first two rounds, that as he was falling to the ground, the shots were fired, at least the victim's mother, and it was as fast as, I think she clapped, instantaneous, right? And then there's this pause of a minute or two where then the evidence or the testimony is the Mr. Dotson stands over the victim and fires the additional rounds. Am I wrong on the record?
If I may have a moment I have the record in front of me. I believe I have it tabbed, if I may have a moment to look. So what I read in the record is that the way I read the record is that RJ's up against into the wall and it's like an instant second, bam, turn around. He hits me with the gun close enough that it only took one step, loses consciousness, gains consciousness again, slams RJ into the wall. He was limp. He turned to the gun and said, I'm looking if someone hits you in the face. I'm looking dead at him. If I hit you in your face, you're going to remember because you're going to see him hit in his face. She passes out. There's nothing from what I read in the record, and I may be mistaken, that he said that the shooting was instantaneous with him hitting the wall after she regained consciousness. The instant I read in the record was when Mrs. Marks got hit in the face.
Can you help me here? We, as a court, frequently, it seems as of late, are getting a lot of cases regarding the distinction between an intentional killing and when that becomes premeditated. And everyone here thought, even counsel thought, the judge thought that this was a very close call on that distinction between something that is intentional and then the line gets crossed or becomes a premeditated act. Tell me what you think in your words. When is that? And I asked that at our last docket, and it is a frequently asked question. It seems like there isn't lately an intentional murder that clearly fits under second degree that also isn't premeditated. So help me here why this fits and a scenario where it doesn't. Where is an intentional murder not premeditated? Because there's a distinction and a big one, I think, and intended to be a big one, in all aspects.
I agree. There is a distinction between intentional and premeditated first degree murder and second degree murder. My position, if I were trying this case, was the minute that Dotson lunged for that gun when there had been no weapons introduced prior, showed his premeditation to kill. I believe if I were trying this case, that's when I would have argued that the premeditation had been formed, but it continued. It continued through the struggle over that gun.
Why isn't that just, I'm going to intentionally kill this guy? Why is that? Why is lunging for a gun establishing premeditation rather than intent. I mean, we have,
Because what,
go ahead.
not to sound flippant, but why else would you go for a gun but to kill somebody? That's what we hear in the community significantly.
He intentionally killed him.
But he's lunging for the gun for the purpose of killing him, which would be a cognitive process that had reflection. And so he could carry out that premeditated thought. But it wasn't just him lunging for the gun. It was the continued fight over the gun where he had the opportunity to reflect on what he was going to do when he got this gun. And then what he did when he got the gun. As Justice Wall indicated, the coroner indicated the victim could still be alive after 2 minutes of being shot the first time. Those second shots could have contributed to his death even quicker because he could have still been alive. Nobody checked his pulse after the first shot was fired. The coroner's testimony was after 30 seconds, he would have lost consciousness because of his blood loss. So there's still that reflection after those subsequent shots were fired that I intend to kill this person. But in addition, to go back to your first question about the distinction between premeditated first-degree murder and an intentional murder, I would argue that there are several factors that you would have to look at that this court has indicated when it comes to premeditation. For example, if a gun has been modified to be an automatic weapon, I think in those situations, you could make an argument better that that is more of an instantaneous killing because you don't have to go through the motion of racking around. You don't have to go through the motion of continually pulling the trigger. You don't have to go through that thought process because it has been switched from a semi-automatic firearm to an automatic firearm. And the evidence in this case was that it was a semi-automatic firearm. So he had the opportunity to stop after the first round. He did not. He chose to and made the decision to fire a second round to ensure that his victim was going to die. So I think you have to look at the facts and circumstances of each case to make sure there is sufficient evidence of premeditation. And here you have it based on the defendant's entire course of conduct during this fight. That kind of goes to the claim of prosecutorial error with regard to the temporal element. If I remember correctly from reading the prosecutor's closing argument, he did say, it was either in the rebuttal closing or the first closing, I apologize, I can't remember which one, either the first prosecutor or the second prosecutor talked about all the decisions he made before taking a life. And then the second prosecutor talked about the temporal element, that it has to be more than just an instantaneous action. Hollywood does make pre-med out to be something that has to be thought out, written down, documented. I have to go to a store. I have to go get cleaning supplies. I have to figure out what I'm going to do afterwards. And his argument is more trying to relate the law to everyday real life, that a plan, a list, a to-done list is not required. A to-do list is not required. It is, I thought, I did. I thought about it, I reflected on it, I did the action that I thought and did. It's like your example in State v. Stanley, eating a cookie. I have a craving for a cookie. I decide to go get a cookie, or I'm going to be good on my diet and not go get a cookie. But if I just go over and reach for a cookie without thinking about it, that would be an intentional, not a premeditated act. The example I use in jury selection is going out to eat. If I go to the local Taco Bell and I go to the drive-through because I'm really wanting Taco Bell, I see the line is out, it's 20 cars deep. The next thing I know, I'm going to Wendy's. I don't even think about not going in because I saw the line. I didn't process the risks and consequences. I just turned and made that decision. Whereas if I decided to have Taco Bell, I would have reflected upon my decision to risk being late back to court versus I really want my Taco Bell. So that while it's not exactly on point, I think that's a good analogy to kind of explain the difference between intentional and premeditated murder.
But when
Uh,
you say it's just more than instantaneous, isn't that a little confusing to jurors because that whole cognitive processing element, how is that captured in a statement like that? That it just has to be more than instantaneous.
I think it is difficult to capture that cognitive processing element, which I think goes to some of the questions that were alluded to. Is the state required to put them both in the same sentence or the same portion of their argument, or can they parse them out to explain the difference between the two? Because it is difficult to explain how, without a psychiatrist on the stand to explain the processing power of the brain, how do we get those facts and evidence so we don't commit error in closing to explain how quickly cognitive processing can go? I think that while it sounds like it's trying to quantify an amount of time, I think it's more just explaining that it's not instantaneous. It's just something more than instantaneous, which this court has said it's not instantaneous. So my position would be that that's not a misstatement of the law, and it's not watering it down or diminishing it, because I believe in closing, both prosecutors talked about the decision-making process of this defendant during the course of his actions. With regards to, we didn't address it on the first part of the argument, but the Stanley instruction issue, we would ask that you follow the law that has been the law in the state of Kansas for over 20 years. Premeditation is already defined by Pick, that the Brohard instruction and the Stanley instruction are more than just what is required. While they may be helpful to some juries, it could create some confusion to other juries, especially if they're not given, unless this court wants to change its position on requiring that it be given. In State v. Stanley, this court said that the Stanley instruction should be given if a Brohard instruction is given. Neither were requested in this case, and the court did give the standard Pick instruction for the definition of premeditation. Unless there are any other questions, I will stand on my brief.
I see no questions. Thank you.
Thank you.
I would argue that if going for a gun is premeditated murder, that makes every murder committed with a gun in this state premeditated murder by default. And that's the problem. What they're talking about are intentional acts. And they're blurring the line such that there is no difference between premeditated murder and intentional murder. The legislature has made a difference, a big difference. My client faces a life sentence because of that.
Do you have any, and I know this is not in the record, but I guess, I mean, it might be helpful to know, do you have any, is there any data that suggests defendants are no longer being convicted of second-degree murder in Kansas?
I don't have data, and I can say anecdotally, I get a ton of first-degree premeditated murder cases, and they usually give second-degree intentional. And off the top of my head, I cannot think of one where they come back with second-degree
So
intent.
the reason for that question is it just strikes me that these sort of hypothetical, I'll call them logic puzzle type arguments, because that's really what it is. You're making a logical argument about definitions. What it really elides or leaves out of the justice process is the jury's decision making. So if a jury is properly instructed in the law, it's really not up to us to say, well, logically, you should have done this or that or the other thing, is it?
I think the problem here is that this court has to be able to say, this is premeditated murder. This is intentional.
We have said that. We have a very clear definition
I would argue the definition is not clear
But-
because everything becomes premeditated
I
murder.
understand that's your argument, but it.
I mean,
Again,
it's-
I don't know how you sustain that argument without, data that suggests in reality, secondary murder as a conviction has gone away.
I would argue to this court, this case is a good example of the problem with premeditation in this case. The testimony that I'll read to you is from the victim's mother. This is an eyewitness, and her testimony was, one quick movement, bam, hit you on the floor. It's not like you can break it in pieces. There was no pause. It was bam, 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 hit on floor dead. Question, and no pause. It was one quick time it happened. The first shot, yes.
Well,
That's from volume
That's
14.
true, but on the flip side, the state was able to present a number of decisions or things that happened leading up to that. And then you submit it all to the jury. And that's kind of the heart of my question is, I understand there's evidence in favor of intentional rather than premeditated. And then there's evidence that might favor premeditation. And our system suggests that so long as the law is properly explained to the jury, we give those questions to the jury. And it just seems like and again, as Justice Rosen said, we've had this discussion several times now. It strikes me that it's an effort to take that question out of the jury's hands.
I would disagree it's an effort to take it out of the jury's hands. I would argue it's an effort for this court to draw lines so the jury can properly apply the law. You can't just say it's up to the jury. We're supposedly a nation of laws, right? That means this is premeditated, this is not.
Do you
And
have
that's
a proposed alternative definition of premeditation you want us to adopt?
I would think there are a couple, and I've cited to them in my brief. I believe the Webster's definition where it talks about a plan and showing evidence of an intent to carry out that plan. I also believe that the Stanley instruction does go towards that end to say, look, premeditation, you have to show he decided to do A and he took steps toward that end. And I think that's what's missing in the way we talk about premeditation in cases right now. It's just intentional. And I know this has been a discussion among this court and my office before. I'm going to reiterate it. There is no difference between premeditation and intentional as it's defined by this court and applied in this state.
I'd like to go back to what Justice Biles asked about earlier. And the thing is, at the trial, it is the state's burden to prove beyond a reasonable doubt that cognitive part, what's going on in the defendant's head and when. And you've been talking about the moment from when he gained control of the gun to when he fired that first shot. Ms. Rayler was talking about, no, I think it was a longer period of time. I think his cognitive intent, premeditation plan to kill started before he gained control of the gun. And at the appellate level, we have to look at the evidence and say, okay, could the jury have taken these facts and inferred this cognitive element? Could they have? That's how we look at it. Justice Biles made a comment about not the moment between the control of the gun and the first shot, which was essentially the kill shot, but the next shot, the shot to the groin, when he was standing over him and he shot his groin with an AK-47 rifle. That didn't kill him. According to the record, that didn't kill him. But what's your best argument that doesn't support a rage that started before the defendant gained control of the gun?
I don't think it shows premeditation because, number one, it is after the fact. I know you want to take it and say, well, does it show something before the fact? And I don't think you can break up this argument that was between these two individuals. If you're going to say premeditation can come during the act,
During the fight.
during the fight, that I think undermines this idea that premeditation has to be beforehand. You're saying you can form premeditation as you're doing it. And I don't think that's what premeditation means. So I think you have to look at something before fight in this case. To say that,
Before he lunged for the gun, he had to form the intent to kill him?
I would argue yes. I don't think you can form premeditation during a fight. I know this court has case law that says otherwise, but if you allow that, again, I go back to the argument, it's just intentional. That's all it is. Thank you.
Thank you. Thank you to both counsel for your arguments this evening. We will take this appeal under advisement.